Hello friends, welcome to Oliveboard. I hope you're all doing well and your exam preparations are going good too. In this video, we are going to discuss the securities market awareness which forms a part of syllabus for SEBI Grade A Officer Examination 2018. Now, in this particular video, we are going to discuss the legal issues and regulations which is done by SEBI for the capital market. Please note that this is part 3 of the series for capital market. If you've not watched part 1 and part 2, I would request you to please go to our YouTube channel and watch them after this video. Now, please note that after we finish with the video, it is very important for you to take up mock tests, for which you can go to the description box of this video and click on the registration link and take up a free mock test by Oliveboard. Please note that by taking this, you will know that what are your strengths, what are your weaknesses, and how can you work on your weaknesses to convert them to your strengths. Before we get started, don't forget to subscribe to our YouTube channel to never miss an update on any videos that we are uploading for you. We will start with the market regulation. Now, we should first know that why is it important to regulate any market? This is to ensure smooth working of the capital market, because we know that there are many players who are associated with this particular market, which leads to the economic growth of our country. Now, along with this, we know that there have been many laws that have been passed time to meet this particular objective, that is to ensure the smooth working of the capital market. Now, for this particular thing, there was initiation of reforms in the year 1990 to 1993. Now, this led to the establishment of SEBI, which is Securities and Exchange Board of India. The main legislations governing the capital market are the following. First is the SEBI Act of 1992, which established SEBI. This was done to protect investors and also to develop and regulate the securities market. So it is very important. The second important legislation that was passed by the Parliament was the Securities Contracts Regulation Act 1956. This regulates the transactions that happen or occur over the stock exchanges. The third one is the Depositories Act of 1996, which provided electronic maintenance and transfer of ownership of demat securities. The fourth and the last one is the Companies Act 2013, which sets out a code of conduct for the corporate sector with respect to issue, allotment and transfer of securities, and also with respect to certain disclosures which are to be made public. Now, we will be discussing all these in detail. We will start with the SEBI Act of 1992. Now, this particular act established SEBI with statutory powers. Now, the establishment of SEBI was mainly first to protect the interest of the investors. So, anyone who is investing in the securities market, the investor's interest has to be protected. So this was one of the major reasons behind the establishment of SEBI. The second one was promoting the development of securities market, and the third is to regulate the securities market. Now, to ensure that it functions very smoothly and to also regulate that there is no malpractice happening in the market were the few reasons behind establishment of SEBI. Now, the regulatory jurisdictions extends over corporates on the issuance of capital and transfer of securities, in addition to all intermediaries and persons who are associated with the securities market. So, SEBI has jurisdiction over the corporates who are issuing shares to get capital for their companies. So, this is one regulatory work of SEBI. It also conducts inquiries, audits and inspections of all concerned and adjudicate offences under the Act. So, in order to ensure that everything is transparent, smooth, clear, It also conducts audits of the various corporates that are engaged in the securities market. It has powers to register and regulate all market intermediaries and also to penalize them in case of violations of the provision of the Act, rules and regulations made under. So in case any corporate or institution is not following correct practices or is violating the provisions of the SEBI Act of 1992, the SEBI can make sure that it can penalize them for all the wrong activities they are conducting. It also has full autonomy and authority to regulate and develop an orderly securities market. Next is the Securities Contracts Regulation Act of 1956. So, it provides for direct and indirect control of virtually all aspects of securities trading and running of stock exchanges. Also, it aims to prevent undesirable transaction in securities. So, it gives the central government or SEBI regulatory jurisdictions over first stock exchanges through a process of recognition and continued supervision. So, SEBI will have a jurisdiction over the stock exchanges and also all the processes, and it will also supervise these stock exchanges. Contracts in securities. So, any contract a particular company enters into with investors, so over that also SEBI will have complete control. Listing of securities on the stock exchange. So whenever there's an IPO which is happening, which is initial public offer, so any company that wants to have its first IPO, SEBI will regulate the listing of their securities on the stock exchange. So, as a condition of recognition, a stock exchange complies with pre-described conditions of central government. They have to go ahead with all the conditions the central government or SEBI has given to them. Organized trading activity in securities takes place on specified recognized stock exchange. So everything has to be recognized for activities to be conducted on the stock exchange. The stock exchanges determine their own listing regulations which have to conform to the minimum listing criteria set out in rules. So anyone who wants to list their stocks in the stock exchange, they have to fulfill a basic set of criteria which are mentioned in the rules. The third important act is the Depositories Act of 1996. Now, this provides for the establishment of depositories in securities with the objective of ensuring free transferability of securities with speed, accuracy and security by making securities of public limited companies freely transferable subject to certain exceptions. So, according to the Depositories Act, they have established basically two depositories that we spoke about in the previous video. This is NSDL and CDSL. So these depositories were established to ensure that the transferability of shares from one person to another happens freely in a speedy manner with accuracy. So all the public limited companies, if they are dealing with securities, they will be freely transferable. The second is dematerialization of securities in the depository mode. So to avoid papers, so to avoid movement of papers or to make it a paperless transaction, there has been dematerializing of securities, that is converting the paper or the shares in paper form to electronic form. Third is providing for maintenance of ownership records in a book entry form. So these depositories have a book entry form wherein all the transactions that occur with respect to any securities are recorded. Now, in order to streamline the settlement process, the Act envisages transfer of ownership of securities electronically by book entry without making the securities move from person to person. So what we do is we do not make the securities move from one person to another. We just transfer the ownership of securities electronically. Supposingly, person A is selling a security to person B. So what we do is electronically change the name of ownership from A to B, who is the new owner. The Act has made the securities of all public limited companies freely transferable, restricting the company's right to use discretion in effecting the transfer of securities, and the transfer deed and other procedural requirements under the Companies Act have been dispensed with. So this is just to ensure that the securities that are transferred are freely, with speed and with accuracy. The next important legislation with respect to the regulation of securities market is the Companies Act of 2013. Now this particular act has replaced the Companies Act of 1956. The new Companies Act envisages to strengthen the existing regulatory framework on corporate governance. Now, to ensure that there is effective corporate governance, the Companies Act was passed. It deals with issue, allotment and transfer of securities and various aspects relating to company management. So, if there's any issue by a company, or there's allotment of shares to individuals by the company, or there has been a transfer of securities from one person to another, or there's anything with respect to management of the company, their MDs, CEOs or anything, so it is all being dealt under the Companies Act of 2013. It provides for standard of disclosure in public issues of capital, particularly in the fields of company management and projects. Information about other listed companies under the same management and management perception of risk factors. So herein, under this particular act, there needs to be a disclosure about the issue of capital, about the management, the various projects a company is undertaking, and the other perception with respect to any risk factors. It also regulates underwriting, the use of premiums and discounts on issues, rights and bonus issues, payment of interest and dividends, supply of annual report and other information. So underwriting is a work which is taken up by investment or merchant bankers on behalf of the company to smoothen the journey of IPOs for the companies. So any activity that includes underwriting or issuance of shares either on premium or discount, or payment of interest to bond or debenture holders, or dividends to the equity or preference shareholders, or the annual report on the performance of the company. So all this is also being dealt in the Companies Act 2013. Now we will deal with the securities market reforms and regulatory measures to promote investor confidence. Now, to ensure that the investor is not cheated upon, or to ensure that there is enough confidence by the investor on the amount he or she is investing in the securities market, the SEBI has taken various initiatives that we will be discussing now. So, SEBI has come a long way since its inception as an institution regulating the Indian capital market. It has initiated a lot of reforms to make the market more safer for investors. The following are the major policy initiatives taken by SEBI since its inception. So, first is the control over issue of capital. Now, this was a major initiative of liberalization was the repeal of Capital Issues Control Act 1947 in May 1992. So, in the interest of investors, SEBI issued disclosure and investor protection guidelines. Now, this is very important because disclosure and investor protection guidelines allow the issuers complying with the eligibility criteria to issue securities at market determined rates. So the market moved from merit based to disclosure based regulation. This is to ensure that they don't charge any particular price or hike in the issue price based on the merit of a particular company. Hence, SEBI ensured that there is enough disclosure happening by the particular institution or corporate or company to ensure the investors' protection. Second is the establishment of regulator. So SEBI was established as a statutory autonomous agency to provide reassurance that it is safe to undertake transactions in the securities. So SEBI was established in the year 1992 to regulate over the securities market. The next important reform was the screen-based trading. So when we talk about screen-based trading, it is an initiative taken by SEBI to start a nationwide online fully automated screen-based trading system. So this particular screen-based trading system is something where a member can punch into the computer the quantity of securities and the prices at which he wants to transact, and the transaction is executed as soon as it finds a matching sale or buy order from a counterparty. So supposingly I want to buy a particular share. So consider I want to buy the share of Infosys company at say 1000 rupees. So whenever there is someone who also wants to sell the Infosys shares at 1000 rupees meets the screen-based trading system, so the transaction is automatically executed. That's how it works. The next is risk management. So a number of measures were taken to measure the risk in the market so that the participants are safe and the integrity is also protected. Hence, the trading cycle that varied from 14 days to up to 30 days, and the settlement took another fortnight. So the rolling settlement on T plus 5 days, which is the transaction day plus 5-day basis, was introduced in phases, and all these scripts moved to rolling settlement from December 2001. Because it took a long time, it became difficult or very risky for the investors to trust the particular buyer or the seller. Hence, the T5, which is the transaction day plus 5-day, gave way to T plus 3 days, which then next gave way to T plus 2 days from April 2003. So now whenever a transaction takes place, within 2 days, the settlement is also done with. The next is the Depositories Act. As we already discussed, the earlier settlement gave rise to settlement risk. So what is this settlement risk? The time taken for settlement and due to physical movement of paper. So since the buyer and the seller can be at a distant places, and to move the paper or the or the share certificate from person A to person B took a lot of time. And the transfer of shares in favor of purchaser by the company also consumed considerable amount of time. So to obviate these particular problems, the Depositories Act was passed. This is to provide the establishment of depositories in securities, like we already discussed. So now whenever a transaction takes place, the change in ownership happens within 2 days of the transaction taking place. Next is with respect to derivatives. So the Securities Contract Regulation Act was amended in the year 1995. This is to lift the ban on options in securities. Why was this done? It was to manage the risks better through hedging, because hedging tries to reduce the risk, or through speculation and arbitrage. Next is the settlement guarantee. So a number of measures were taken by SEBI to ensure or to address the risk in the securities market. Now, one of those was clearing corporations that had emerged to assume the counterparty risk. Along with this, there is Trade and Settlement Guarantee Fund, which were set up to guarantee settlement of trades irrespective of default by brokers. So initially there were problems wherein the brokers never paid the amount to the sellers of the securities and there was no guarantee. Hence, to remove these particular ambiguity with respect to payment for securities sold, the clearing corporations and the trade and settlement guarantee funds were established by SEBI. Next is the securities market awareness. Now, to educate the investors about the risk associated with the market as well as their rights and obligations, SEBI has launched nationwide securities market awareness campaign. Green shoe option. Now, as a stabilization tool for post-listing price of newly issued shares, SEBI has introduced green shoe option for IPOs, which is initial public offerings. As I already told you, the first time when a company issues shares or lists shares in the stock market, it is called initial public offer. So, one green shoe option was introduced as a facility only for the issuance of initial public offers by the companies. The next important reform is securities lending and borrowing. As we discussed, the clearing corporation or clearing house, after registration with SEBI under the scheme for securities lending and borrowing as an approved intermediary, may borrow securities for meeting shortfalls in settlement on behalf of the members. So if there is any shortfall in the settlement on behalf of the members, they can reach up to SEBI and the clearing house or the clearing corporations, and they can manage the temporary shortfalls. The next is the corporate governance. Now, as we already spoke about it, the Companies Act of 2013 that had come up. So, SEBI amended clause 49 of the listing agreement. Now, the major changes in this new clause 49 included provisions related to the definition of independent directors. So any independent director who's appointed, every detail has to be made transparent or public. Any things pertaining to party transactions or audit committees or disclosures with respect to financial. There were also clauses like the whistleblower policy or restriction of term of independent directors. So all these things were a part of the corporate governance to ensure that the market is transparent. Next reform is debt listing agreement. So further to develop the corporate debt market, SEBI prescribed a model debenture listing agreement for all debenture securities issued by issuer irrespective of the mode of issuance. Next is gold exchange traded funds in India. So this was another announcement that was made by the finance minister in his speech for 2005 and 6, and post this SEBI appointed a committee for the introduction of gold exchange traded fund in India. So based on the recommendations that were provided by the committee, SEBI Mutual Funds Regulation 1996 were amended and notification was issued on 12th January 2006, which permitted mutual funds to introduce gold exchange traded funds in India certain to investment restrictions. So things like this also, which were said by the government, were incorporated by SEBI in the securities market. Guidelines for issue of Indian depository receipts. So, SEBI had also issued guidelines on disclosures and related requirements for companies desirous of issuing the Indian depository receipts in India. SEBI also prescribed the listing agreement for entities that issue Indian depository receipts. So, this also we've dealt what are global depository receipts, what are Indian depository receipts. So for this you can go to the previous videos on our YouTube channel and you can watch them. The grading of initial public offerings. So grading of all IPOs was mandatory. So this grading would be done by a credit rating agency that is registered with SEBI, and it is mandatory for all the companies who want to go for initial public offerings to have their credit rating done by an agency, and this particular rating should be disclosed in the prospectus and in every advertisement for the IPOs. This was to ensure that the investors know how much secure it is to invest in a particular security. Next was the introduction of fast track issuances. Now, to enable the compliant listed companies to access the Indian primary market in a time effective manner through follow on public offerings and right issues, SEBI introduced fast track issue mechanism. Now this was for all the companies who have obliged to all the regulations of SEBI. The SEBI introduced these fast track issuances to make the issuance process little faster for all the listed companies. The next was mandatory requirement of PAN, which is permanent account number, for all the transactions in securities market. So according to SEBI, PAN would be the sole identification number for all the participants in the securities market. Now the objective was to strengthen the know your client norms through a single identification number for all participants in the securities market to facilitate sound audit trail. The next important reform taken by SEBI was corporate debt market. So in order to develop a sound corporate debt market in India, SEBI took a number of policy initiatives in respect to the following areas. So it has set up a reporting platform for corporate bonds, a trading platform for corporate bonds where people who already have a bond can go and trade in the bonds, issues pertaining to trading in corporate bonds. So if there's any problem being faced by any investor to carry out trading in the corporate bonds, was taken care of by SEBI, making amendments to listing agreements for debentures, issuing securitized debt instrument regulations, evolving policy guidelines on debenture trustees, introducing repos in corporate bonds. So we know what is repo rate, right? So introducing repos in corporate bonds, then facilitating setting up of quote dissemination platforms wherein the quote for a particular security, we understand that what is the fair price for a particular security, simplifying corporate bond issuance norms to make the process little faster and easier, framing of draft issue and listing regulations for corporate bonds. So these were the few steps or reforms taken by SEBI to ensure that the debt market, or to make sure that things go smoother, or these initiative helps both the issuers and the investors. Setting up of SME Exchange, which is Small and Micro Enterprises Exchange. So SEBI decided to put in place a framework for setting up new exchange or separate platform for existing stock exchange having nationwide terminals for small and medium enterprises. In order to operationalize this particular framework, necessary changes were made to applicable regulations, circulars, etc. So as per the framework, market making has been made mandatory in respect of all scrips listed and traded on SME Exchange. Next is the business responsibility reports. So SEBI inserted clause 55 in equities listing agreement. which mandated inclusion of business responsibility reports as part of annual reports for listed entities in line with national voluntary guidelines on social, environmental and economic responsibilities of business that was issued by Ministry of Corporate Affairs. Now, this will also ensure how the particular organization is meeting its responsibilities or business responsibilities. SEBI also notified the SEBI Foreign Portfolio Investors Regulation 2014 to simplify compliance requirements and have uniform guidelines for various categories of FPIs like foreign institutional investors or qualified foreign investors. That's all we have for you in this video. I hope you liked the video. Do share it with your friends who are also preparing for SEBI Grade A examination. If you've not subscribed to our YouTube channel yet, please go ahead and subscribe now to not miss any videos from us. Don't forget to take up the mock test and evaluate your performance and make your study more smoother and confirm your selection for the examination. Thank you.